In the court since 9 o'clock as scheduled by the judge. We didn't see the face of the Attorney General. Other cases were being adjourned. We were waiting until all the cases were clear, giving an impression that, look, this case is what matters to the judge the most. Now, yesterday, I filed a motion for prohibition in the Supreme Court, saying that we are not comfortable that this judge will give us justice. I brought it to the attention of the judge. I also raised an issue that we should adjourn the case and abide the outcome of the application to the Supreme Court. The case is just next week in the Supreme Court. The judge is saying no, he won't grant us the adjournment, and that he is ready to continue the case. That's why the judge is in an ambulance route to continue the case. I cannot wait for the Supreme Court for 1 week. The list matter to be designed. And I'm caught between the rock and the hard place. How? The ambivalence that you want to disqualify a judge from hearing the case and you sitting to continue the case. I cannot answer in the Supreme Court, so I need to leave the chamber. And leave him to do what he wants to do best. That's why I've left the court.
Are your client not going to be? Your client is still.
Well, my client is there. I know he can't do any legal work for himself, but they should be glad that the lawyers are saying that they can't continue with the case. They could have also gone out of the court, but they are accused persons because they agree with me. But because they are accused persons, they can't get out of the court. That's why they are there. Because they are accused, but not that they endorse what the judge did.
If you go to the Supreme Court, we are not preempting, and the Supreme Court sends you back to the High Court, how will your approach be?
Well, let's leave it to the Supreme Court. I don't want to play clairvoyance, but I think we have a good case for the Supreme Court to consider. That's what we are doing. We don't know what the Supreme Court will do, and you don't want to play lottery with this very sensitive case.
But Counsel, regarding the decision by the judge, he cited two conflicting authorities and decisions by the Supreme Court, for which reason he used his discretion to refuse your application. How does that come to you, seeing that you chose to walk out when really he used discretion?
What discretion is on this matter, in which there is an old authority, the Supreme Court has departed from the authority. And the Supreme Court in 2020 is asserting that when there is a pending application for prohibition and the lawyer tells the judge looking after the affairs of the case that, look, adjourn the case and let's wait for the Supreme Court to determine the matter. And if the judge should not do that, it implies that the judge is biased.